At the University of Chicago and teaching at a variety of schools, which you can find listed in the bios in your program. So keeping with the tradition of the bios short so the substance can be long, I will turn you over to your programs to learn more about Dean O'Hara O'Connor and turn it over to Erin to get our panel started.
Thank you, Donald. Hello, everyone. Good morning. It's great to see, I've been sitting in the back, so I've seen the back of your heads for the last couple hours. It's great to see your faces. We have four wonderful discussants today. We've got two members of the Academy and two individuals who are in elite private practice. I'm going to introduce them all at once and then turn it over to each of them to speak for 8 to 10 minutes. We've left ample time for questions, so I really do hope you submit questions for this panel. Presenting first will be Jeffrey Parker. He has spent the last 30 years as a professor of law at George Mason University, Antonin Scalia Law School. After several years of private practice, he focuses his research and his teaching on both procedure as well as criminal law. Next presenting is David Bernstein, University Professor and Executive Director of the Liberty and Law Center at George Mason University, Antonin Scalia Law School. David actually has several areas of expertise, but one of them has been sort of following the evidentiary standards and the kind of revolutionary effects that we've seen over the course of the last 2 to 3 decades on litigation. And then third is Tom Sheehan, who's a partner at Shook, Hardy & Bacon. His practice is focused exclusively on product liability and health effects litigation. And then finally, Ed Casmere, who's a partner at Riley, Safer, Holmes, and Cancila. And his practice focuses on commercial and business law litigation, as well as corporate litigation. So we'll start with Professor Parker.
Thank you, Erin. I sort of took this engagement as an opportunity to sort of update myself on what's happened since Daubert, and therefore I prepared what I've called my notes on experts in science that is actually up to date and starts with Daubert and tries to take it down to the present. I think what's useful and what I'd like to stress in the brief oral remarks that we have is what my perspective was, which was that I thought the audience would be mostly trial court judges, which I think is what you are. And so I tried to orient my comments in the direction of the trial court judge. Now, Erin's pointed out to me there are also quite a few appellate court judges, and I think those persons can look at this as trying to empathize with what the trial court judge is up against. And many of you who were previously trial court judges. Now, the key message I have for all of you, actually, is reassurance. Don't worry. I mean, you heard a lot of very sophisticated, complex things in the lectures this morning, and they were wonderful lectures, and I'm not criticizing them. But there's a tendency, and I think there has been a tendency ever since Daubert was announced, for lower court judges to wonder, what the heck am I going to do with all of this? You know, I am no scientist. How am I supposed to implement all this stuff? And that's where my reassurance comes from. I mean, the first one to voice that expression, by the way, was Alex Kozinski, who was the person who got Daubert back from the Supreme Court. And he said the same thing. Now, what's happened, though, since that time is that the doctrine has evolved. There are helpers out there for you. It's been mentioned the National Academy of Sciences has pitched in with the Federal Judicial Center to create the vastly different 3rd edition of the Reference Manual on Scientific Evidence, and they're now working on a 4th edition, I heard this morning. So that help is out there if you need it. But I think generally speaking, you don't need it. The main thing you need, I think, is to go forward a couple of clicks in the evolution of the Daubert trilogy, as it's been called. And the case that I would like to focus your particular attention on is Kumho Tire, written by Justice Breyer. Now, this case has a lot of significance to it from many different points of view, but I'm, again, thinking about the trial court judge. And what Justice Breyer did that was brilliant, I thought, was that he wrote the opinion as if he were a trial court judge. And remember what happened in that case. It was a case disputing whether a tire blowout was caused by a defect or misuse. Not an exotic question. And the expert in question was an engineer, one Carlson. Now, the district court judge conducted a preliminary proceeding, which is something I recommend in my 9 rules for trial court judges at the end of my notes. I didn't have the gall to make 10 rules like our friend John Davis did when he was discussing the argument of an appeal. But the rule is just think about your case. Don't think about what your other colleagues did. Don't think about what the consensus of the scientific community is. Just think about your case. And again, and let me quote from Justice Breyer in Kumo Tire, because what he does is he goes down, he puts up a diagram of what a tire looks like. You know, not high-powered stuff, but just a basic diagram so he can understand what a tire looks like and how it's made. Then he sets out Carlson's algorithm. And then he tests it. He says, well, does Carlson's algorithm explain, as he puts it, the relevant issue was whether the particular testifying expert, quote, could reliably determine the cause of this tire separation. In other words, it's a case-by-case determination, right? So all the trial court judge should do, really, is treat this question like any other question that you would choose to resolve, if you can, in limine, right, with pretrial submissions or hearings, and just decide whether, for purposes of this case. So let me, I don't know, how much time do I have left?
4 minutes.
Oh, I have 4 minutes, only halfway through. So let me emphasize another point about this. I happen to have the pleasure or displeasure, as the case might be, of knowing Justice Breyer, because I worked with him when he was a sentencing commissioner back in the Reagan era, and I was on the staff of the Sentencing Commission. And there was another guy who was a guy by the name of Ron Gaynor, who was one of these super clerks from the Justice Department. He was the ex officio member. And he was really kind of a gadfly, you know, and he took me under his arm and he would describe the characters for me. And he described Stephen Breyer thusly. Stephen Breyer intellectually takes an idea and he runs as fast as he can with it until he crashes into a wall and falls into a lump on the floor. Then a few seconds later, he jumps up, turns around, and runs as fast as he can in the opposite direction. This is intellectually. So that's why he was the perfect choice to write this opinion. His colleagues, I'm sure, knew that about him. And they said, okay, you're the guy because you have no real convictions here, right? Now, he still does write on the subject, but the truth is he's basically a process-oriented person. And he wrote this wonderful opinion that I think you can all profit by looking at and following. And I want to have 2 more little points. I think I have 2 minutes left. First thing is to somewhat challenge the title of our panel, because it's something like, how do you distinguish good science from bad science? Isn't it, Erin? Something like that. Right? And my advice is, forget that. Good, bad, or indifferent. The trial judge's job is really the same. And the trial judge's job is to hold the advocate's feet to the fire and hold them to their preliminary proof by a preponderance that their expert can reliably say something about what happened in this case, like in Kumo, what happened to that tire in this case. That's the test of admissibility. And if they can't meet that standard, inadmissible. Final point, and it's been adverted to several times in the morning, so I made a note of it, about the sociological aspects of this problem of developing scientific knowledge. And in my notes, I do direct you to I say if you can read a single book about this, I would recommend Thomas Kuhn's The Structure of Scientific Revolutions. This is a not very well-known book, but it's enormously influential. It's where the term paradigm shift came from. You've probably heard that, but didn't know where it came from. And that's what Thomas, and now other factors have been mentioned, such as careerism and just fraud, but that's not what he was talking about primarily. He was talking about the seductive nature of groupthink, that because scientists tend to work in a group, they tend to see the world the same way. They develop an orthodoxy. And an orthodoxy is poison to real science. So his point is the only way science actually wins is for some heretic to come along and try to overthrow it. And that is the history of science. I'm out of time, I see.
Thank you. Professor Bernstein?
Yeah, hi. Well, I've been writing about expert testimony and its admissibility since I was in law school, since 1989. So I could go on and on about this, but given 8 to 10 minutes, I am going to limit myself to one issue that is a reasonably common scenario, which is that an expert is asking, or the attorney for the expert is asking that the testimony be admitted, and the testimony is not really based on reliable knowledge, but based on what I would call informed speculation. So to give you an idea of what I'm talking about, let's take a reasonably common kind of scenario in, say, pharmaceutical litigation. Patient is prescribed and takes a drug, let's call it miracle drug. And a few months after he takes miracle drug, he starts suffering immune system problems. And a year later, he gets an attorney and sues and says, I believe that miracle drug caused my immune system problems. Okay, plaintiff's lawyer hauls around, finds a well-credentialed expert named Dr. Smith, who is willing to testify that miracle drug was the cause of the plaintiff's immune system's injury. Defendant then files a motion to exclude Dr. Smith's testimony, saying Dr. Smith's testimony is not based on reliable evidence. There are a few preliminary studies out there on animals, on human subjects, suggesting that maybe, possibly, there might be some issue here with the immune system. But as with many preliminary studies, the conclusion is we need more research. We can't really conclude anything now. And Dr. Smith himself, under questioning, acknowledges that these studies themselves are not really reliable, that we need more information, and that they're not reliable evidence of causation. However, Dr. Smith says, but you have to understand, I just didn't look at the studies. I looked at the totality of the circumstances. I looked at the plaintiff's medical history and other factors and what other things might have caused it, whether he has a family history of this sort of thing. And I conclude, based on this totality of the evidence, that more probably than not, miracle drug causes immune system problems. So Dr. Smith still faces the objection that this is just informed speculation, and that if you look at the rules of evidence, for example, Federal Rule of Evidence 702 as amended in 2000 requires the expert testimony be the product of reliable principles and methods, that the expert witness applies the principles and methods reliably to the facts of the case, and many states have the same or similar standard. And Dr. Smith says, well, that's all well and good, but understand that scientists and physicians have to make judgments based on incomplete information all the time, including in the legal context. Regulatory agencies do it, clinical physicians do it, and so forth and so on. And it would be ridiculous, Dr. Smith states, and his lawyer elaborates upon in the briefs, for the judge to interpret the reliability test to be stricter than what scientists and experts actually do in the real world. Now, one possible response is that you're just a wooden textualist and you don't care what scientists do in the real world. Rule 702 says you have to show me that you've applied reliable facts and data reliably to the facts of the case, and you haven't done so. You've engaged in informed speculation, and that's that. You have to be excluded. And that's fine. But a lot of judges have actually been persuaded, including some courts of appeals at the federal level, some haven't, by exactly this type of argument, which actually seems kind of compelling. How could we hold a doctor or a medical expert or a scientific expert to a higher standard than the scientific community uses? And I think you need to exclude Dr. Smith's testimony in these contexts, and let me explain why. the first thing we have to understand is I think the underlying rationale for having a reliability test to begin with is what I call adversarial bias. Expert witnesses are not drawn from a random pool of qualified experts. In fact, if you were a lawyer for a plaintiff and you just chose a random expert out of a qualified pool, you'd probably be engaging in malpractice, right? Unlike a typical non-expert fact witness, like an eyewitness, you also don't have a limited pool. So you as a plaintiff's lawyer or a defense lawyer are going to a big pool of experts and picking out those experts who happen to agree with your theory of the case. So let's actually look at what the analogy would be to out of court. So I'm going to take two different scenarios. Scenario number one, I am suffering from some sort of malady that causes constant dizziness. I separately consult 5 different experts in the field who, my sister and brother-in-law are doctors. They refer me to 5 experts in the field. One of them says, I don't really know what you have. The other 4 say, oh, there's no objective test for what causes dizziness. I know about this because my wife suffers from dizziness. There's no objective test as to what causes dizziness, but based on our experience with thousands of patients over the years, each of them individually concludes that I have vestibular migraine and that there is an operation that can be done to cure this. It would get rid of my dizziness if I do have vestibular migraine, but there's a 10% chance I would go deaf. Would I be reasonably wise to rely on this, even though they're not really sure, they don't really have a reliable test? Yeah, 4 different experts out of 5 in the field are pretty confident that this is my problem. That's about the best I could do. But let's change the scenario a bit. I get the same mysterious dizziness, and I decide to Google dizziness, and I see an article from WebMD that says there are 8 common causes of dizziness. One of them is vestibular migraine. And for whatever reason, I decide that's what I have. It's vestibular migraine, and I want this operation. I then consult. I spend the next few months of my life consulting 20 different experts around the country. 19 of them either say they have no idea what I have, or they say I have something other than vestibular migraine. The 20 that says, you have vestibular migraine, I don't have an objective test, but based on my experience, the totality of the evidence, that's what you have. And I say, great, schedule the operation. Now you say, well, that's crazy. That's not reliable evidence. It's one thing if 18 or 15 or even 12 of the 20 experts thought you had this, but if only one of them said that, and they don't have a reliable test, it would be one thing if they told you, well, a new peer-reviewed study just came out, but they're just speculating, and why trust his speculation over the other 19? So the second scenario is a lot more analogous to what actually goes on in a typical tort case when scientific causation is an issue, or at least it may be going on. The plaintiff's lawyer isn't really looking for the best evidence, or the defense lawyer, but the plaintiff has, of course, the initial burden of proof. But they're not getting a random sample of expert opinion. They're looking to find an expert who agrees with the theory that, in this case, miracle drug caused immune system disease. And unlike me, where at least I could know that I'm getting only one of 20 experts who agree with my theory, the jury never hears about the other 19 that you may have contacted. That's all well, which doesn't mean that 20th expert is inherently wrong, is inherently unreliable. But the reason we have a reliability test is to ensure that if we're going to omit that expert whose views were solicited because they agree with the theory of the case that's being promoted, that they have a reliable basis, an objective basis. If we are just allowing an expert to say, trust me, I'm an expert, I looked at the totality of the evidence, I can't give you a specific methodology or a specific rationale, but I just know, well, how do we know that this one expert really represents what people in the field would think, as opposed to being extremely idiosyncratic? So in short, opinions based on informed speculation are really nothing like out-of-court scientific opinion based on incomplete information. The real world of science and medicine is like scenario 1. We're trying to figure out what I have dizziness. I want to know what it is. I want the best opinion. In the courtroom, it's much more like scenario 2. I've already decided what the answer is, and I'm looking for someone to validate what I've already decided. And again, if you're a lawyer looking for medical or scientific causation, there's hundreds, thousands of epidemiologists, toxicologists, physicians out there. So it's not like you have a limited pool to choose from until you find someone who agrees with you. So again, if Dr. Smith can provide an objective basis, and we're relying on what the Dauber court called the mere ipse dixit of the expert, then under this scenario, I think the reliability test needs to be applied as written, and you need to exclude the evidence. Thank you.
Thank you. Attorney Sheehan?
Okay, thank you very much. Good morning, everybody. I'm really, really glad to be here in front of you all today. Given the distinguished speakers that preceded me, I feel like I got to start with just a couple of caveats. First of all, I am not a professor. I am not even a scholar. And last, and of course most important, I am certainly not a judge. So my perspective is a little bit different, but hopefully complementary to the other speakers. Let me give you a little bit of a background just to kind of set the stage for myself. I'm a practitioner, so I'm kind of in the trenches. And for the last 20 years or so, I have focused on pharmaceutical product liability defense. And so I represent pharmaceutical companies. You've probably all seen the ads on TV, late at night. If you've taken X drug and you've suffered X harm, give me a call. I work mass torts, multi-district litigation, some one-off cases, that type of thing. But even within that sphere of the legal profession, I occupy a niche that I like to call the intersection of the law and science. So I work with experts, I work with expert witnesses, I work with company scientists, I depose experts, I defend expert depositions, I give science days to judges, I argue Daubert motions or Frye motions or whatever the standard might be. That type of thing. That is my niche. So basically everything that I do is imbued by my understanding of the underlying science. But I think when I started, that wasn't necessarily the case. I kind of took a little bit of a path to get where I am today. So I started like probably a lot of people. I had a law degree, I considered myself reasonably bright. But nothing special, nothing that would say, hey, this guy's going to know a lot about scientific principles or scientific methods. But I was fortunate, I was lucky actually, to be drafted into a practice group where everybody had a PhD or an MD in addition to their law degree or some master's degree and some advanced degree in a scientific field. And I'm working in that group and I'm learning things on the go and had a great mentor, brilliant woman, who looked at me one day and said, Tom, go back to school. Go back to school and get a degree in something. And I did. I got a master's degree in epidemiology. This is probably 7 years out of law school, something like that. And it fundamentally altered my view of the evidence that I dealt with on a daily basis. I think it sparked what I'll call a scientific curiosity that I think is required to really discharge the gatekeeping role that you all face as trial judges. And this, the scientific curiosity, I think it starts you down a path to be able to kind of separate the wheat from the chaff, the good from the bad, the reliable from the unreliable. And I've had the opportunity to work in cases involving cancer, involving heart attack, teratology, birth defects, that sort of thing. Lots and lots of different areas. So my degree in epidemiology doesn't necessarily translate to all the scientific areas that I have to understand. But it's that scientific curiosity that was sparked in me that I think informs the practice. And one thing that I've noticed, and it goes back to something that David was saying and that Jeff was saying, every litigation I've worked on, every single one without fail, there's a little kernel of truth in there. There's a good idea there. There's something underlying the allegation or the proffered testimony. But a good idea isn't good enough. It's got to be a reliable idea. It's got to be reliable testimony. It's got to be tested in some way so that you have that underpinning that allows you as the trial judge to say, hey, I think this should pass the gate. I think it passes muster. I think they've met their burden here. And obviously there's going to be some instances where you can kind of really see something as junk. I think judges do distinguish the junk pretty readily. You know, you can kind of sniff it out, right? If the allegation is a heart attack and the expert that's being proffered is a child psychologist, you kind of say to yourself, well, what's going on here? What's the deal? And you can kind of sniff those cases out. But when you've got that well-credentialed expert, when you got that expert report with 200 citations, and it sounds like a plausible idea, this idea of plausibility, that's where it becomes difficult. I think you guys have a hard job, and that's where that scientific curiosity, I think, becomes essential, because you got to look under the hood a little bit. You gotta delve a little bit into what is the basis for this opinion. And to a certain extent, I think it requires an amount of fearlessness, because I think there's a natural tendency to look at scientific data and say, gosh, you know, there's confidence intervals and p-values and Bonferroni corrections, and you know, this is about developmental biology, or this is about genetic polymorphisms. There was somebody, you know, that talked earlier today about genetics, and to say I'm not trained in that. This is difficult stuff. How am I supposed to know that this guy is offering an unreliable opinion? But I think if that scientific curiosity is sparked, you're starting down the path to ask those tough questions and engage in the science. And I do think that requires a little bit of fearlessness. Because what does it mean to be a gatekeeper, right? I mean, you've got to be armed to a certain extent. And I'm obviously not talking about having a sidearm, you know, during a Daubert hearing to force that witness to tell you the truth. But to be sure, you've got to have the tools, right, to be able to ask the probing questions. And I'm not up here saying, hey, y'all got to run out and get a degree in some scientific discipline to discharge your duties. Not at all. I think the tools that were mentioned earlier are critical. So use your tools. You know, hold hearings, hold science days, use the reference manual. Engage an independent advisor if you feel that that's what's necessary for you to discharge your duties. And be curious and be fearless in probing the reliability of any opinion that's being offered in your court. Because if you can't do it, if you can't satisfy yourself, the jury's not going to be able to. They're not going to be as well positioned as you all are to really execute that gatekeeping function in a reliable way. And I would just add a couple of things before I hand it over here. There's a great quote from Thomas Huxley that gets to this idea of, well, a beautiful hypothesis from somebody isn't good enough. And it's the great tragedy of science is the slaying of a beautiful hypothesis by an ugly fact. And keep that in mind, because the history of science is littered with great ideas that weren't borne out when they were properly tested. And make yourselves literate in those scientific principles. Another great quote from Neil deGrasse Tyson is, to be scientifically literate is to know when someone else is full of it. And he didn't use the word it, he used another word that rhymes with it. But you got to have that scientific literacy. You got to have that curiosity. You got to have that fearlessness to engage. And I think that if you're willing to engage, my experience anyways, is that if judges are willing to engage, to start down that path and really grapple a little bit with the opinions that are being offered, you're 90% of the way there to making a solid decision. And I don't care if the decision goes my way or the decision goes the other way. Actually, that's a lie. I do care. But what is critical, I think, is that engagement, that curiosity. So I would just say, be curious, be fearless, and engage. And with that, I'll turn it over to Ed.
Well, I certainly feel intellectually underdressed being in this room and on this panel. It seems like nowadays the only thing it takes to be an expert is to have a Twitter account or a Facebook account. I mean, I didn't know so many of my acquaintances were infectious disease specialists or constitutional scholars until the last year and a half. But everybody feels free to share their opinions. My background is similar to Tom's. I've spent the last 20 years trying cases, mainly in the toxic tort environmental law area. And in 2007, I was trying a case in Los Angeles, the Hill Street Courthouse. And I was commuting every week from Chicago because my kids were little. And I had a trial partner who was a mentor of mine. And the trial lasted in total about 4.5 months. And halfway through the trial, my mentor had a stroke in the hotel on a Monday afternoon before we went in to court. And we went to the hospital that night, and I think it was this left side of his brain was just completely obliterated. And the doctors told him, he'll probably never speak again. He won't ever be able to read again, and certainly won't ever be able to practice again. And he beat the odds, and part of the way that he beat those odds was that he asked me to engage with him over the next year and a half to read Shakespeare, of all things. Now, I had never read Shakespeare really in my life other than like the one or two plays in high school. So as I read through all the Shakespeare plays with him as part of his rehab, I've come up with sort of 9 tips from William Shakespeare on how to recognize good science in the courtroom. And I'm going to share those with you now. And I've categorized them, and I'll start with a quote. The first one is, "Heaven truly knows thou art as false as hell." It's from Othello, Act 4, Scene 2. Example, conflating correlation with causation. Right, this happens a lot, and I think you have on the agenda tomorrow a discussion about that. If you took the divorce rate in Maine from 2000 to 2009, that has a 99.26% correlation with the per capita consumption of margarine. The charts look identical. If you took the per capita cheese consumption, that correlates with the number of people who died becoming tangled in their bed sheets, a staggering 94.71% of the time. Correlation and causation are not the same, and there's a whole bunch of great examples on spuriouscorrelations.com. Number 2, the breaking of so great a thing should make a greater crack. From Antony and Cleopatra, Act 5, Scene 1, when Cleopatra learns of Antony's passing. Beware of the experts that will negate the applicable legal causation standard. This happens a lot, particularly in the toxic tort area, where, for example, there might be a substantial factor causation standard, but the expert will say, each and every exposure is a contributor. Each and every exposure is a substantial contributing factor. And the rationale there is they can't exclude one, so they all have to be in. But the law in most places, not California, but in most places, requires a substantial factor causation and says that de minimis exposures cannot be causative. So you have to beware of the expert that's trying to supplant the legal causation standard. Because legal relevance isn't just about scientific validity and reliability, but it's also not about rewriting the law. Number 3, nothing emboldens sin so much as mercy. Timon of Athens, Act 3, Scene 5. Beware of the experts that pay lip service to the legal standard for admissibility. A reasonable degree of medical certainty for some experts means something different in the courtroom than it does in science. And experts have testified that they think it is a lower standard because in the courtroom you only need a preponderance of the evidence. So they will testify to things in a courtroom that they won't say or publish in the literature. And the whole idea of Daubert or Fry is to keep the bad science out of the courtroom, not to invite it in. But there are experts who think because there's a preponderance of the evidence standard that they can lower their threshold of what it is that they give to the court and jurors. The point is to keep the bad science out of the courtroom, not to let it in. And another warning sign for experts like that are people who can't cite to anything in the peer-reviewed literature that says what they just said in their report or on the stand. or that they only cite the things that they wrote, and that they can't find anybody else in their community that will say what they are saying. Number 4, the empty vessel makes the greatest sound. Henry V, Act 4, Scene 5. Beware of the experts who give scientific opinions that have not been validated by controlled experiments or objective testing. That the opinion is purely subjective and only subject to their subjective interpretation. Some examples are bite mark evidence is often an example of this. Visible dust experiments to correlate to exposure levels, another type of example. But it's not all or nothing. And I think expert testimony on the admissibility of science about memory is something that's changed quite a bit over the last 20 years. It's one thing for an expert to come in and talk about how memory works and how memory doesn't work and how memories are formed and the common misperceptions that people have about memories, like, you know, it's not a video camera or you can't automatically recall things. There's science behind that. But it's a totally another thing to have somebody come in and say that this particular witness's memory is bad. Right? Those are two different things. And the law, particularly in Illinois where I practice, has changed. The Supreme Court in Illinois has changed over the last 20 years on that type of issue. So it is evolving, and it's not all or nothing. Number 5, those that understood him smiled at one another and shook their heads. But for mine own part, it was Greek to me. Julius Caesar, Act 1, Scene 2. 2 hallmark warning signs of suspect science in the courtroom. Is number 1, the scientific underpinning cannot be explained in the terms that a non-expert can understand. It's really difficult, so trust me, I'm an expert, I'll tell you what it means. That's a hallmark sign of science that's suspect. The second is the scientific underpinning of the opinions just defy common sense. Another warning sign. Number 6, oh, it is excellent to have a giant's strength, but it is tyrannous to use it like a giant. Measure for Measure, Act 2, Scene 2. Beware of experts that won't stay in their lane. Tom referred to it earlier. Experts will drift. Once you give an expert the mantle of expertise, some experts will take that and think that they can talk pathology, maybe a little toxicology, maybe a little epidemiology, maybe a little radiology. You know, they would just all mix it in there all together. Courts oftentimes, I think, not being a judge, I don't know, but I do have some friends who are judges, and they've told me this, are reticent to sort of impose on an expert sometimes once they're in a courtroom. The expert will not have any problem whatsoever imposing on you, imposing on the court, or imposing on the law. Once they're in there, they need to stay in their lane, but experts often don't. And that's a sign that you're drifting into bad science when an expert goes outside of their lane. And it's also a sign if they're up there testifying to things in an area where they wouldn't be allowed in the room if it was a medical conference. You know, if you have somebody coming in and said, for this opinion, it's a pathology opinion, but they wouldn't let that person on the stage at a convention of pathologists. They shouldn't be in the courtroom giving that opinion, but they will. Number 7, one may smile and be a villain. Hamlet, Act 1, Scene 5. Beware of experts who are only testifiers. Beware of experts that only get all of their income from testifying. They can put on window dressing. They will write in their reports the magic words they think they need to get over Frye or Daubert or the Frye Plus standard wherever you are. But they can be a wolf in sheep's clothing. So those are the types of experts that you need to give a little extra scrub to, in my humble opinion. And by the way, it's easier now than ever before in the history of science to get published. Online, there are new journals that are popping up all the time. It is very easy to get published. It's very easy to create a CV that's got a lot of publications on it. There is a great website called Retraction Watch that will show you how frequently things are being retracted and who the authors are and what scientific journals have high impact factors and have low impact factors and whether or not they're often retracting their publications. My last two. Number 8. This is a twofer. Because I couldn't have 10, I could only have 9 following Professor Parker, so I had to put 2 into 1 here. Fair is foul and foul is fair, and what's done cannot be undone. Macbeth, Act 1 and Act 5. Not everything can be fixed on cross-examination. I understand the desire to let everything in and let the lawyers work it out. And frankly, I've heard many times how someone has said, that's a really great argument, Mr. Casmere. I look forward to hearing it on cross. That's flattering, and I don't know any trial lawyers that don't have a big ego, so that's very helpful to that. But at the end of the day, sometimes letting in that stuff and then making the lawyers cross-examine it lets the jury hear it twice rather than none at all. Because a lot of that cross-examination has to rehash those same points that should have never been in the first place. And my last one is, uneasy lies the head that wears a crown. Henry IV, Part 2, scene, Act 3. It is a burden on the courts to hold these hearings. It is a lot of work, and as you've heard people talk about, there's a lot of effort that needs to be put into that. And that is not something that the lawyers and the parties will take lightly. But holding these hearings will hold people's feet to the fire, and it should be done. It will push people to rethink their experts. It will push people to rethink their cases. It will ultimately make for better trials and better evidence. So please, hold our feet to the fire. Make us put the evidence on. Make us make it understandable. Thank you.
Thank you. A reminder to submit questions. You can join at slido.com, #Destin2021. I've got a couple of questions here so far, one for the academics and one for the practicing attorneys. For the academics, there is the question, what advice or to what extent does your advice differ depending on whether the judge is dealing with a civil or a criminal matter?
Unless David wants to take it, I can answer that because it's addressed to some extent in my notes. Because I looked at a couple of case studies, and of course my original paper back in '95 predicted that criminal prosecutions would be problematic, more problematic under Daubert because of the mismatch between the incentives and resources involved in a criminal prosecution. Now, since that time, I'm afraid the situation has gotten worse, at least in the federal system. Because as you may or may not, though district court judges will be well aware, federal district court judges will be well aware of what I'm talking about, which is the Interlocutory Appeals Act in criminal cases. It's been expanded, I think in 2002, wasn't it? And it's now being used to some extent as a threat on in limine motions. So that's one difference. The other difference, of course, is I have these two case studies that I just picked because they're interesting illustrations, but both of them have to do with so-called forensic science, which has fallen from its lofty perch here in the last 11 or 12 years or so, ever since the National Academy of Sciences started looking into it. And among the things that have fallen are fingerprints, frankly, which are now conceded to be subjective opinions and perhaps not even science at all. That doesn't mean they're always inadmissible because the experts have now been trained. They're being taught at the FJC website to admit that it's a subjective methodology. They aren't so sure as they were before. So in other words, there are some, as somebody else indicated, there's some intermediate solutions to some of these problems, so long as you are willing to police the way the thing is framed. And finally, I want to mention one other thing from forensic science that I think is very significant to the overall mindset. And it's in my rules. I use a quote, too, from Hamlet. There are more things in heaven and earth that are dreamt of in our philosophies. Hamlet to Horatio, Act 1, Scene 5. And I accompany that with the point that there are, as far as we know, there are no unicorns, but there are human chimeras. And most of us in this room probably haven't even heard of a chimera, don't know what it is. But what it is an individual single organism with more than one DNA profile. And this was learned by the legal system in a case involving Miss Lydia Fairchild in Washington, who was being accused of welfare fraud on the ground that she wasn't her son's mother. But a retesting based on a similar case that had come out in the New England Journal of Medicine showed that she was her son's mother because she was a chimera. Now, not only are natural human chimeras quite well known to the scientific community, as I point out in my notes, the first medical journal report was in 1953, the same year that the original DNA articles were published. So it's not a new thing. There is still a debate on how common it is, but we also now know that it's a condition that can be induced. And the main culprit in the artificial human chimeras is bone marrow transplant. This almost routinely produces a person with two different DNA profiles. So that's the gold standard, right, of forensic science. And so that's why I emphasize just be a skeptic about everything and make the lawyers prove up what the experts are saying. David, do you have anything to say about this?
Sure, yeah, I've actually been a bit disappointed that there's been a lot of criticism of a lot of forensic science, but judges are still, I think, very deferential. I think there's a good reason or several good reasons for the deference. One of which is that if a jurisdiction's been relying on fingerprints or glass analysis or voice prints for decades, and all of a sudden you're like, oops, this isn't reliable evidence. It's kind of embarrassing. We've been convicting people for 30 years. Maybe some of those people don't belong in jail, and it opens up a big Pandora's box of people filing motions for reconsideration of their cases and so forth. But it turns out, unfortunately, a lot of things that courts have been relying on basically since the 70s did not really have adequate testing, and a lot of it was really subjective opinion. And once again, subjective opinion isn't so problematic if you have people who have some true expertise and you get a random sampling, like if you called 4 fingerprint experts in who've shown they could identify people pretty well and all 4 agree. The problem is when a forensic scientist is coming into your courtroom, and I use scientists loosely because most of them really, sometimes these are just police officers who've had a 2-weekend seminar on something, so scientist is a little generous. But when forensic experts come in, they work for the prosecutor. I found this out. This should be a big scandal, but it's not. I've been meaning to write about it. But there's actually an economist somewhere who discovered that in some jurisdictions, some states, the forensic science laboratories only get paid if they help get convictions. So their salaries and their funding depends on how helpful they are to the prosecutors. This is not a system you'd want to get objective expertise. So it's a real problem. A lot of trial judges are former prosecutors themselves, so they're sympathetic, and there's also political implications, and there's all sorts of issues. But we have to understand that when you have subjective opinions and we have a group of forensic science labs that are attached to the prosecution and sort of an arm of the prosecution, that there is reason to be skeptical. And I think overall, judges on the one hand haven't been skeptical enough, and when the occasional very courageous judge really gets into the science and says, oh my God, fingerprints are problematic, or radar detectors could be problematic. I actually looked into radar detectors when I got a ticket, and I didn't think I deserved it. And I discovered that the laser gun that the cop was using, you're supposed to be out of the police car and kneeling, and you have to hit the right point of the dash. And if you do it from the police car, it's completely invalid. And I noticed by cops in Arlington, Virginia, where I live, they all just sit in the police car. It's air conditioned or heated or whatever. So all their laser tests are invalid unless they've changed the gun they're using. So anyway, when judges do sometimes get into this, they suffer a fierce backlash often, and they often then get reversed in appeal, and they get threatened that the various prosecution groups are going to oppose them for re-election, and so it's a real problem. But I would just reiterate what Jeff said, that if one is doing one's job, you don't want people getting prosecuted and thrown in jail for 5, 10, or 20 years based on really bogus evidence. You need to start out with some real skepticism, and also recall that your poor public defenders maybe have 200 cases on their docket, and they're not going to be able to present the sort of defense to the evidence that the clients who are paying $800 an hour are able to do. So of course it's not your job to step in for them, but you may need to be a little bit more proactive about making sure that the forensic scientist evidence is really admissible, that you might be in a civil case.
Thank you. Question for the litigators. Before I read it, though, there's a separate question just for Mr. Casmere, asking whether you'd be willing to share your quote outline with the audience.
Certainly.
And then the substantive question, can you compare litigation differences? I'm sorry, wrong one. How frequently have you had a judge refuse to admit expert testimony when the opponent did not object?
So the question is, refuse to admit it when the opponent did not object.
Do you see judges being independent scrutinizers, or are they relying on opposing counsel to raise a problem?
Well, first let me say I wish I made $800 an hour. So the opponent doesn't object doesn't respond to the Daubert motion or something? I'm not sure I'm understanding. The opponent doesn't object to the...
I think some of the presentations we've heard this morning are asking judges to be independently skeptical and independently scrutinizing. And so the question is, in your practices, how often do you see that as opposed to leaving it to opposing counsel to raise the issue or the problem?
Oh, I see. Okay. So, gosh, in the world that I inhabit, it's routine that there are challenges to expert testimony. So I'm not... I've certainly experienced judges going beyond what a particular motion seeks. So I think it's very, very judge dependent. And in my experience anyways, there's a variability in how aggressive and rigorous a particular judge will be with respect to a gatekeeping role, whether it's under Frye, whether it's under Daubert, or what have you. So I've certainly seen what I think is a very independent or streak of independence in the judge that analyzes proposed testimony beyond the confines of a particular motion, if that's helpful. I'm trying to think of a time when there was simply no motion pending and the judge said, this person's out. And I don't know that I've seen that.
I would say in my experience it's extraordinarily rare. It's usually a fight in almost every case that somebody's objecting to somebody else's expert. I can't think of an instance in the last 20 years across the country where a state or federal judge has sua sponte decided to challenge the admissibility of an expert when the other side didn't oppose it. I'm sure it happens. I guess I would be I'd be embarrassed if the judge did it and I didn't object, and I'd be upset if the judge wanted to go after my expert and the other side didn't. So that probably means it's probably the right thing to do.
Thank you.
That being said, give it a try.
It's probably the right thing to do if both sides hate it.
I think it's usually done by a suggestion from the bench. Mr. So-and-so, are you going to object? Usually that produces the desired result.
This is a question that I think is designed to get you guys to talk about a difference that has been implicit in your comments so far. The question is, if orthodoxy is poison, then how do we distinguish between the visionary heretic and the lone expert who is not grounded in science?
Yeah, this may be a difference between David and myself. If you want to speak first, my answer is it doesn't matter. If you just follow Kumho Tire, it doesn't matter. Does it work or doesn't it work? If it works, more likely than not, admit it. If it doesn't work, don't admit it.
I would just say that, orthodoxy, I wouldn't call it orthodoxy is usually right, or at least the best we could do right now. And the Galileos of the world, while they have a huge impact, are really rare. So if you go with the orthodoxy, you're probably a lot less likely to make a mistake. But moreover, the odds that it's going to be, no offense to the gentleman who lays the room, the odds that it's going to be a trial judge who discovers the next Galileo as opposed to the scientific community, it strikes me as, it's possible, but it's more likely that well, in general, we're facing, I can think of people who've challenged orthodoxies in courtrooms. There was a whole group of people called clinical ecologists in the 1980s who they called it clinical ecology or environmental syndrome or 20th century syndrome, where they said, oh, we have a new paradigm that, this whole germ theory and these other things we look at, actually, if you're just exposed to a chemical, your whole
I think they were also
system,
called forensic toxicologists or something like that.
there were a whole bunch of different names because there'd be an opinion eviscerating clinical ecology, so then they come in calling themselves something else. But this whole theory that if you're exposed to radiation or a chemical or whatnot, then your whole immune system could shut down, and therefore any disease that you now get could be attributed to your exposure, which is very good if you're litigating, obviously, because you could attribute any disease anyone got from a dioxin spill to this. And they were claiming, well, this is just not orthodoxy, but the community will eventually come around, and of course, it didn't, and so it was nonsense, and it remains nonsense. There are unfortunately people who believe this and wind up living in a hut in the desert so they're not exposed to any chemicals.
And again, that's where we differ. To me, the proof comes at trial when you show it works. It either works or it doesn't work. If it isn't shown to work, don't admit it.
In practice, they had no tests to show this.
Well, in that case, it's not admissible.
I think at the end, we'd agree on the outcome.
Can I let me just add real quick on that. I think one of the reasons for Daubert was to permit novel testimony that was not yet generally accepted, right? I mean, that's sort of the big distinction between Daubert and Frye. And it goes back to what these guys were saying. Is it reliable or is it not? And you've got to apply the factors to determine whether the proposed testimony is reliable. There is a decision, I believe it was by Judge Easterbrook. It gets quoted all the time. You've probably seen it before. Law lags science, it does not lead it. And I think that's a good sort of guiding principle when you're evaluating this. If there's like one guy out there and he is trying to be the next Galileo, maybe a little heightened skepticism around the testimony that's being offered.
I would add that there is a real tension here because particularly today with our science and technology and the developments, we're moving so fast. And I don't know if it was on the agenda this morning or not, but I do a lot of cancer-related cases. And so the Genome Project and the way that we are diving into finding out what genes are being turned off or turned on or deleted or altered in some way and how that may lead to specific substances causing different types of cancers. It's moving. Every day it changes. And so there's a real tension between what's out there and known and what we're developing and the way that the science is moving. So I think the bad news is that it makes the job of the trial judge harder to figure out and sort of separate the wheat from the chaff, so to speak, from that. But it's going to continue as long as our technology continues to move in that direction. And there are groups that are challenging long-held views. The linear no threshold model and whether or not that applies to low-dose causation is under review. There's lots of things that people have held for years and years and years that maybe new science is suggesting otherwise. And so I think it's only going to get more difficult, not easier, going forward.
Also, let me make one more distinction here, which would be between orthodoxy and scientific orthodoxy. Because there are some things that are orthodox in the relevant community that have never actually been tested scientifically, that people just accepted. This is very much true in the forensic sance context, which we just mentioned, where a lot of techniques were done without ever really being scientifically tested. It's also true, for example, in the medical community. I did a lot of research when my wife was pregnant on what techniques should and should not be used and what we should and should not agree to in the delivery rooms. We had 3 kids. And it turns out that millions and millions of episiotomies were done on women delivering babies without anyone ever bothering to do a study as to whether this improved healing or detracted from healing. It turned out it detracted overall when someone finally bothered to do a study. So that was an orthodoxy. It was just an orthodoxy that had never had an underlying scientific basis, and there's no reason to particularly credit that simply because it's an orthodoxy. If there had been, on the other hand, 30 peer-reviewed studies on it, that's an orthodoxy, that's a different matter.
Thank you. This question we've been talking around, but someone asked if you would compare litigation differences between the Frye and the Daubert jurisdictions.
I assume that's for the practitioners.
Yeah, let's start there.
Do you want to?
Go ahead. I'm the caboose.
I mean, I think I commented on this earlier. I mean, to me, the big distinction is whether or not something's generally accepted, which is a bit of a, I guess, in my experience, things have really moved to Daubert, right? There are certain jurisdictions that still apply Frye, but even within those jurisdictions, I find that people are really sort of surreptitiously applying Daubert to determine whether or not the testimony is reliable, because there's more of a roadmap there. There's just more of a substantive analysis that goes to the heart of the proffered testimony. Frye, in some ways, is more restrictive, because it is going to be a simpler inquiry. Is this generally accepted or not? I mean, can you point me to the textbook? Can you point me to the manual? Can you point me to the consensus statement that exists in the relevant field to show me, yes, this is a generally accepted method, or this is a generally accepted causal theory, or whatever the case might be. But I do think there is that continuing trend to embrace Daubert and apply those factors that are outlined.
I agree that there is a trend towards Daubert, and so I definitely agree with that. I think in practice, the difference between Daubert and Frye is summed up this way. In Daubert jurisdictions, the courts really dig into the reliability of the ultimate opinion. And what is that really standing on, and is that opinion reliable? And that's what becomes focused on in the hearings. In Frye jurisdictions, it really is just about the methodology. So an expert in a Frye jurisdiction could testify that the moon is made of green cheese as long as she was able to say that she followed the methodology that got her there. And that's where I think the difference is in practice.
I would add also on general acceptance, one of the things I develop in my notes is a strange transformation of that. General acceptance to whom is the real issue. It's supposed to be to an expert community, peers of the testifying expert, but in the fingerprint case, it's generally accepted by the courts. But that's not what that ever meant, right? And somehow they got off kilter, and that's how they kept fingerprints alive for another 8-9 years beyond what should have been their natural death with the Brandon Mayfield case. So there's a little bit of confusion there. Otherwise, I agree with what's been said, that clearly, just because everybody thinks it doesn't make it so, right? Whatever group you're looking at. And as we know, things change over time. That's what we know. So
there's also, at least in some Frye jurisdictions, and so many courts have abandoned Frye recently, it's hard for me to keep, I haven't taught my scientific evidence class for a few years, so I haven't investigated this, but there have been some cases where appellate courts in Frye jurisdictions have said, well, Frye is really about keeping out junk science, and about, which is not which is a step beyond unreliable, and it's also about science. So not only we only go look at methodology, but if the expert is not actually engaging in science, Frye doesn't apply to begin with. So this really weird dynamic in some states. I remember Pennsylvania was one of them. I don't remember what the status is in Pennsylvania at this point, but at some point where the court said, well, this expert just basically made it up. It has no methodology, so there's nothing to be generally accepted. So Fry doesn't apply, and all we look at is qualifications. Now, I thought this was a really weird way of dealing with expert testimony. That if someone is relying on some studies, but the studies aren't so good, we'll exclude it. But if they don't have any studies at all, we won't even examine it. So that is very much contrary to the general trend with regard to expert testimony around the country. But there are still some courts that do it, and in some of the states, like New York, California, that were Fry, the courts have made some intimations towards that we're going more towards a Daubert-like version of Fry, but then it's not specific enough. You really don't know what the individual trial court's going to do, because it's still, officially a Fry state. So they don't have the federal precedent to rely on as you would in Rule 702 state, nor have they adopted the amended version of Rule 702 that makes things more specific. So I think there's also more uncertainty in Fry jurisdictions, as far as I can tell.
David, I wanted to ask you, I think it was one of our scholarly colleagues, in Winklereed.
Yeah.
He gave a good example of the critique of Fry, that dowsing would meet the criteria. That's the thing where you hold the stick and you find.
Well, it depends who you
They had a society of dowsers, they had a peer-reviewed journal, and this is not my critique, it's his. But your distinction would account for that, right? You say you don't just need a club and a journal, you need to have scientific principles.
Right. I mean, in fairness to the judges who have said, well, non-science doesn't have to come in, their view is, well, science really is confusing to the jury and this and that, so we have to make sure there's some reliability, so they'll have to make sure that even if they don't understand it, at least we know the verdict is okay. Whereas if something just like dowsing, you could, a good lawyer should be able to show that dowsing is not.
It doesn't work, right?
But there's no underlying
that's not
methodology.
really part of Fry, the original test. So as you say, there's been an evolution, I think.
I have a question here that has both a positive and a normative component about hearings in this area. So the positive, how often do judges deny a hearing based upon the motions? And second, do you think a hearing should be granted in all requests for a hearing?
Who's requesting the hearing? Is this the opponent? I mean, usually the opponent is going to request the hearing, right? And it seems to me that unless the case for admissibility is clear on the papers, the request should be granted.
Well, I mean, a lot of our colleagues here are trial judges, like in state courts. So what I hear over the years is that, well, it's all well and good to say that to a federal judge who has 3 clerks and.
Yeah, I understand. I know it's
but
uncommon,
state judges don't have those resources. So I wonder if you guys have found.
Well, even federal judges don't grant these hearings very, very frequently. Isn't that true, gentlemen?
Gosh, I've seen it go both ways. In the majority of the time, given that the world that I occupy are these big MDLs and mass tort situations, whether it's a state equivalent, a JCCP or whatever have you, there'll be a hearing. And whether that involves live testimony from the experts themselves, whether it's just attorney argument, there can be great variability in the circumstances of the hearing. But for the most part, if you ask for that hearing, a lot of times both sides want the hearing, and there will be a hearing. I've been involved in hearings that go for weeks. I've been involved for hearings that go for an afternoon, and the circumstances are wildly variable. In instances where the judge has said, "I think I got this. I don't think we really need a hearing," I can usually predict the outcome there. So, the judge, of course, judge is king. The judge can say whatever they want and have a hearing or not have a hearing. But in most instances, in the area that I practice, we typically have one.
It's more frequent in federal court than state court. It's more frequent in cases where it's sort of a first of its kind, particularly in mass tort or really interesting new theories of causation. You'll have it more frequently than not, but particularly in the state court level, most of the time we don't even argue motions in limine. It's just show up, we thought this case would settle, and okay, let's bring in the jury and let's go. We'll deal with that as we go.
I have one more thing. And let me just give you one individual experience of a case I was consulting on. District of Nevada, federal court, large-scale prosecution trying to ruin a doctor. And the defense had moved for an exchange of written expert testimony statements pre-trial. That motion was granted. On the basis of what was in the statements, the defense moved to strike some of the government's experts. The court declined the motion to have a hearing. Case went to trial. Expert testified, and he was shown to be a liar. The judge had to dismiss half of the complaints, and the other half went to the jury dubitante with 26 not guilty verdicts. So 52 not guilty verdicts and a multi-million-dollar federal criminal prosecution predicated on a lying expert. So that's another issue that I think judges should be aware of. Experts lie. The state of a man's mind is as much a fact as the state of his digestion is the famous quotation. So the judge says, I'm sure of this. If the expert says, I'm sure of this, he could be lying and just making a buck. So that's another thing, but that's the kind of problem I think these trial court judges are well aware of, right?
Well, you also,
I don't have to tell you that.
having worked at a big firm for a few years after law school, I mean, defense lawyers are very risk averse about their clients. They don't want to miss something that they could have won on. So you'll get these books of motions eliminated before trial, which range from really, really serious, important issues to, well, we'd like to win this, but it's not that big a deal. And again, if you're a federal trial judge and you have 3 clerks and a lot of support, you'll go through a lot of these. I feel for the judges who have a huge docket of both civil and criminal cases to try to get through and come up with one of these. But and the temptation would be, I'm not going to grant any of this because I don't have time to look through this. And I think judges don't have a lot of authority over trial management, and you could respond by saying, I don't want 162 motions eliminated. Give me your top 3 or give me your top 10 and I'll consider those. And then that makes things a lot easier.
Okay, I think we have time for one quick question. It looks like we've got a couple of the judges who are looking for more information about what to do, I think, in the event where opposing counsel does not object to expert testimony. So they're basically asking, what is the court's proper gatekeeping function? Does it only arise when an expert is challenged, or is it inherent in the court's role for every case?
I'll answer it because typically, if the other party doesn't object, unless there's some reason to doubt the adequacy of the advocacy on that side, so again, we would be talking about criminal cases, basically, where the defense is perhaps ineffective. Aside from that, you can't really force somebody to object if they don't want to, and the judge, I think, would be wasting his or her time in going through that exercise if the opposing counsel doesn't object, and unless there's reason to believe that somehow the opposing counsel doesn't represent the best interest of their client.
I mean, I think in the criminal, I think judges would not exclude evidence on that grounds. What you might do, especially if I were a judge and there was a criminal case and someone's going to jail, 30 to life, and the evidence just seems really sketchy, but the overwhelmed PD doesn't seem to be on top of it. You always have the inherent authority to appoint your own expert.
That's true, yeah. But with that exception, what can the judge really do? The judge can't replace the opposing advocate. Not really. You'll never know as much about the case as the lawyers do.
Yeah, and in the world that I operate in, if there's a reason to challenge, you challenge. So I've not experienced sort of the judge going rogue, so to speak, and just taking out somebody's expert without there being a request.
Well, I would say if it smells fishy to you, go ahead. And frankly, there are times when advocates may not challenge somebody because they want bogus stuff to come in so that they can rip them apart on cross. And it's just a matter, do you want to spend the jury's time and your time with that? So if it smells bad, it might be, and I think it's ultimately up to the judge to decide what they let in and what they let out. I think that's kind of the rule.
Please join me in thanking our wonderful panelists.
And thank you, Dean O'Hara O'Connor, for leading our panel. So what's next is lunch. So if you can go outside and construct your lunch out there, and then bring it back to your seats. For those down in the tent,